Hello friends, today you are going to see introduction, definition and legal provisions related to preparation of final accounts of banking companies in India. Subscribe this channel for more videos and press on the bell icon for notifications. Let us see the introduction of banking company. What is banking company? As per the Banking Regulation Act, banking company means a company which transacts the business of banking in India. It means a company which doing a business of banking in India is called as banking company. Now, what is banking or what is banking business? Banking Regulation Act section number 5B defines banking as accepting deposit from the public for the purpose of lending money or investment. These deposits are payable on demand or otherwise and withdrawable by check, draft or order. Then what are the functions of bank? The main functions of banking company are to accept deposits of money from the general public and to lend or invest these deposits. Banking company also provide various facilities and services. Some of the activities as per the section number 6 of the Banking Regulation Act 1949. The banking company may also engage in the following important activities: the borrowings, raising or taking up of money, the lending or advancing of money either upon or without security, the drawing, making, accepting, discounting, buying, selling, collecting and dealing in bill of exchange, promissory notes, coupons, drafts, bill of landing, etc. So bank acting as an agent for an government or local authority or any other person or a group of person. Bank also acts as a contracting for public and private loans and negotiating and issuing the same. Every banking company have to follow as per the Banking Regulation Act 1949. These are the important legal provisions. Restrictions on the business, non-banking assets and its disposal, capital structure of the bank, reserve fund, statutory reserve, cash reserve. There are restrictions on loans and advances, bills for collection, acceptance, endorsement and other obligations. These are the important legal provisions. Now we can see one by one. Restrictions on business. No banking company can directly or indirectly deal in the buying or selling or bartering of goods except in connection with the realization of security given to it or held by it. It means banking company does not buy or sell goods. Second one, no banking company can engage in any trade or buy or sell or barter goods for orders except in connection with bills of exchange. It means banking company does not buy or sell goods except in connection with the bill of exchange. It means in the bill of exchange, banking company can buy or sell goods for their clients or for their customers. No banking company can hold shares in any company other than its own subsidiary company. It means State Bank of India can hold shares in their subsidiary companies. For example, State Bank of India can buy shares from their subsidiary companies or subsidiary bank. Next one, non-banking assets and its disposal. Banking company cannot acquire certain assets, but it can lend money against the security of such assets. Naturally, if the borrower fails to repay the loan, the banking company can take possession of such assets offered as security. Such assets are called non-banking assets, and these assets must be shown separately in the balance sheet as non-banking assets in schedule number 11. It means the reader of the balance sheet, the stakeholder of the banking company, can easily identify the non-banking assets of any banking company from the balance sheet, and these non-banking assets are specially separately mentioned in schedule number 11. Any income from such assets must be shown separately in the profit and loss account of the bank. So, some profit or income earned from these assets which will be shown separately in the profit and loss account of the bank. Capital structure. So, the capital structure of the banking company should be according to the section 12 of the Banking Regulation Act 1949. The subscribed capital of the banking company must not be less than 50% of its authorized capital. It means subscribed capital should be more than 50% of its authorized capital. Paid up capital must not be less than 50% of its subscribed capital, and the voting rights of single shareholder should not exceed 1% of the total voting rights. So this is the provision regarding capital of the banking company. So as per the Banking Regulation 1949, every banking company has to maintain these percentage in their authorized subscribed capital, paid up capital, now reserve fund. So every banking company incorporated in India shall create a reserve fund out of the balance of profit of each year as disclosed in profit and loss account, which is prepared under the section 29 of the Banking Regulation Act, and before any dividend is declared, transfer to the reserve fund a sum equivalent to not less than 20% of such profit. It means the 20% amount from its profit, bank has to transfer this 20% amount to the reserve fund every year. Where a banking company appropriates any sum or sums from the reserve fund or the shares premium account, it shall within 21 days from the date of such appropriations report the fact to the Reserve Bank explaining the circumstances relating to the such appropriations. Statutory reserve, according to the section 17 of the Banking Regulation Act 1949, it is mandatory for every banking company incorporated in India to create a reserve fund and have to transfer to it at least 20% of its annual profit as disclosed by its profit and loss account before declaration of dividend. Cash reserve. Section 42 of the Act requires that the scheduled bank should maintain with the Reserve Bank of India an average daily balance of at least 3% of its total time and demand liabilities in India, but the Reserve Bank of India has been given powers under Section 42 of the Act to raise the cash reserve up to 20%. It means every banking company has to maintain the balance at least 3% of its total time and demand liabilities in the India. Restrictions on loan and advances. So Section 20 of Banking Regulation Act 1949 as amended by the Banking Laws Amendment Act 1968 provides that no banking company can grant any loans and advances on the security of its own shares. It means bank does not lend money on the security of its own shares, and no banking company can enter into any commitment for granting any loans or advances to or on behalf of. So banking company does not allow to lend money to these people, any of its director, or any firm in which any of its director is interested as a partner, manager, employee or guarantor, or any company of which any of its director is a director, manager, employee or guarantor, or in which he holds the substantial interest, or any individual in respect of whom any of its director is a partner or guarantor. Bills for collection. These bills are received by the bank from its client to collect them on their due dates from the acceptor of the bills credit the amount to the respective client's current account. These bills are recorded in the special book like bills for collection register and are not recorded in the books until they are realized. So they are shown as a separate item at the bottom of the balance sheet. So bills for collection is shown on the bottom of the balance sheet. There is no any schedule number given to the bills for collection. Acceptance, endorsement and other obligation. A bank may accept bills on behalf of its customer and give advantage of its credit to customers. On maturity, the bank collects the amount of such bills from the respective customers and honors them on the due dates. However, if the bank could not collect the amount from the customers whom it was accepted, the bank has to honor the bill on the due date by paying its own money. The bank incurs the second liability either by accepting the bills on behalf of clients or by endorsing the bills accepted by the clients, or by standing security or guarantee on behalf of the clients. So this item is shown as a contingent liability outside the balance sheet. It means these items are shown at the bottom of the balance sheet, which is schedule number 12, contingent liability. So these items are shown in the schedule number 12, which is outside the balance sheet, bottom of the balance sheet. Bottom of the balance sheet.